Visit Elmhurst.org to explore the new City of Elmhurst website. Find out the latest Elmhurst news, pay utility bills and parking tickets, report concerns, and much more. Elmhurst.org is an ideal way to discover what Elmhurst offers your business, your family, your life.
Welcome to Community Conversations. Thank you so much for coming out on such a beautiful day. My name is Kathy Jordan, and I am the chair for the Elmhurst Senior Commission. The commission provides information, advice, and advocacy to enhance the quality of life for adults in Elmhurst. Before we start, I would like to thank a few people. Number one, Lexington, for helping provide the snacks and treats that you had today. That was very kind of them. For Elmhurst City Manager Jim Grabowski, the Mayor Steve Morley, and City Council for all of their support for our commission. I also would like to recognize our commissioners. You know, they're a dedicated group of people, and you're only as good as the people you are working with. Downstairs is Jackie Haddad and Chris Hansen. Up here is Grayson Haller, give a little wave, Monica Barticello, Ruth Maple, and Peggy LoCicero. I'd like to thank them for all of their help. Without them, we would not be able to provide you with this presentation today. I'd also like to introduce you to Helen Fitzpatrick. If she could just stand up for a minute. She's from Metropolitan Family Services. Actually, they're housed right here at City Hall. So if you have any kind of situations that you're not familiar with or you need help with, you can always come and talk to Helen or Angela Benston, who is her partner as well. So without further ado, I'd like to introduce our speaker for today. Attorney Michael LoCicero has been engaged in the practice of law for over 32 years with offices in nearby Oak Brook. He is a graduate of Elmhurst College and received his law degree from Gonzaga University. From 1984 to 1989, he served as Vice President and Trust Officer for the West Suburban Banks. He has been working in the area of estate planning, creating trusts, wills, powers of attorneys for health care, powers of attorney for property for over 30 years. He handles probate matters. A strong believer in community volunteerism, he was elected and served as member of the Board of Education for Elmhurst Community School District as both Vice President and President. He has served as a volunteer judge of election in DuPage County. He is currently on the Board of Directors for the Elmhurst Heritage Foundation, where he currently serves as Vice President. Without further ado, I would like to introduce Attorney Michael LoCicero.
Thank you very much. Welcome, everyone. Good morning. As we all came here this morning, we saw the spring pickup in process. Runners were out. It's the beginning of spring. It's a beautiful morning, unless, of course, you're a White Sox fan. I'm a Cubs fan, so I could say that. I'm pleased to be here this morning, thanks to the members of the Senior Commission, all those volunteers that help promote and put on this program, and to Kathy Jordan. I am an estate planning attorney. That's a confession. That's who I am. That's basically what I do. It's not the most glamorous of professions. You don't see the TV shows that picture us drafting wills and trusts. All those headlines and movies and TV shows go to the criminal defense attorneys and for the divorce attorneys. In a prior life, I've done both. But the area of estate planning affects each and every one of us more than those more glamorous areas of law. each and every one of us has, at some point in time, either in our earlier lives or later in life, will be dealing with death, with health issues, taking care of loved ones, making sure that we protect those loved ones, and all that's encompassed in this area of law that we call estate planning. Now, we're going to have some slides that are going to show up here periodically. I've given you a little notebook, so if you want to follow along in this folder, these slides are reproduced for you. There's some convenient little lines if you want to make notes. You should have a pen that you can do that. You can also use this little notebook if you want to make any further notations. So feel free to scribble. You know, if you want to do caricatures of me or little doodles, feel free. I won't be offended. We'll try to keep this as interesting as we can for the next 40 or so minutes and try to give you as much information as we can. This area of law is so encompassing that there's really no way that I can cover in a good basis in 40 minutes or in 40 hours for that matter. But I'll do the best I can to try to keep this as simple as I can and explain as much as I can in this time period. Because our time is limited this morning, we please ask, I know you're going to have questions as things go on. Please hold those questions to the end. We'll allocate some time after the cameras go off and we'll stay as long as we need to answer your questions. If you need additional information in the future, you can certainly contact me. There's a sign-up sheet out there that if you want me to send you additional information, I'd be happy to do so as well. My goal this morning is to provide to you a brief overview of estate planning. So as I said, this cannot be a comprehensive presentation. So I'm going to spend the focus mostly on lifetime protections for you because I think those are the most pressing needs that affect every one of us. So if I could provide some food for thought this morning and prod you to take some action. I can't urge that enough. We are all, as a society, procrastinators. You know, when we're in our 20s, we're getting employed. In our 30s, we're probably raising our kids. And we're taking care of our kids and we're way too busy. We don't deal with later. We always assume there'll be tomorrow. You get in your 40s, you're dealing with teenagers. You know, and as you get older, you're dealing with other circumstances. And you always say, I've got plenty of time, I'll deal with it later. And then you get into your 50s, in mid-50s, and go, okay, it's getting closer maybe, so it's on my list of things to do. But it always keeps at the bottom of that list. We get older and older, and it's, yeah, I'll do it tomorrow, I'll do it next week, and you don't get around to it. Please, take the time, do the planning while you're capable of doing it before a crisis occurs. I can't stress that enough of how many times I have clients contact me or come into my office, and unfortunately, because of circumstances, there's nothing I can do for them to provide protections for them or their family. So please take those words to heart and plan accordingly. It's always best to consult with a licensed practicing estate planning attorney who practices in the area and knows what they're doing. As we'll talk about a little bit later, the internet is great for some things, not so good for the creation of legal documents. So, you know, those are warnings that I'm going to repeat throughout. So here we are today. Why everyone needs a will and other mysteries of the estate planning universe. I'll kind of cover a few little mysteries. I don't have any great solutions at some of those, but I'll do the best I can. At a minimum, you should have a will. In most instances, you should have more than a will, and I'll explain to you why. And the importance of doing these things is real simple. 4 points. Number one, we're all going to die. I know we don't want to deal with that. This is not the most pleasant topic, probably why we don't get the TV shows. This is kind of depressing in some ways if you look at it in that fashion, but we will all die at some point. That's a reasonably foreseeable event. It's going to happen. And during our lifetime, we've got stuff. We've got lots of stuff. You know, and that stuff ranges from items of real property, our house or a condo, to items of personal property investments in collectibles that we need to do something with at the time of our death, or even to have those things available for ourselves in the event we become incapacitated. And because we work so hard in accumulating all that stuff, we want to control what happens to it at death, and we want to make sure that we can pass that on to our loved ones. And again, the last and another important point is we want to save money on taxes, attorney's fees, and court costs. If you plan and plan ahead and plan appropriately, you can save a lot of money in court costs and attorney's fees, because a good estate plan will again cover reasonably foreseeable events and save some monies in the long run. So reasons why you need to plan. We're going to talk about planning. Some planning is fun, right? Planning for vacations is fun. Planning for parties is fun. We always plan in a lot of instances. We plan to guide our future actions, but we should plan for incapacitation or death. And that kind of planning we don't always do. In the estate planning world, if you plan, not only do you have a plan that's going to protect you, but it gives you peace of mind to know that those things are in place, and it also provides some certainty so that if you become incapacitated or upon your death, you know what's going to happen. You have controlled it, you have decided what that plan will be, and it will, if it's done legally, will be legally enforceable. Now, understand you can't plan for everything, but as estate planners, we try to cover reasonably foreseeable events, such as, I may be alive tomorrow, but I may not. And if I die in the next few days, I may very well leave a surviving spouse. Or I may not leave my surviving spouse, but I may leave children. And I may leave some of my children, but maybe not all of my children. And maybe some of those children have some special needs or problems that I need to take care of. Or maybe I have grandkids, or maybe I won't have grandkids. All those things are reasonably foreseeable life events that I can plan for in my estate plan. Believe me, the best kind of planning is done when you're calm and rational and have the time to do it. Crisis planning is not the way to go. I can't tell you the number of times that I get phone calls from clients where they come into the office and it could be a child saying, you know, my mom or dad don't have a will, they need a will. Well, I need to talk to mom or dad and let's see what they want to do. I'll be happy to help. But then it turns out, well, mom's been diagnosed with dementia and mom's in a nursing home. And then you painfully have to explain, well, if mom doesn't have legal capacity, and that is the ability to understand your actions and to perform them in a legal fashion, then there's nothing I can do for her. And it's unfortunate, and it's a sad situation. And the result of that lack of prior planning means that there's a guardianship in court, there's additional court costs, there's attorney's fees, all of which could have been avoided if there was a good estate plan in effect long before mom was diagnosed with dementia and became incapacitated. Now, your response may be, if you're my generation, you know, I'm 60 this year, so in my generation, my parents did no estate planning whatsoever. You know, they were a World War II generation. They didn't have much, and maybe that was why they didn't do any planning. Until I became an attorney, my dad didn't have a will. I made him get a will. I set up a trust for him at some point. But as I was growing up, they had nothing. They had no documents in place whatsoever. Had something happened to one of them, myself and my two sisters would have been hard-pressed to be easily able to carry on and have access to assets. And again, in the old days, things were simpler. Our parents didn't have a whole lot. And maybe you did what was the seat of the pants estate planning. And that was, you know, we've all had aunts and relatives that have done it. There's collectibles throughout my apartment. And when something happens to me, you know, pick it up and there's a sticker underneath. And that sticker was going to say who gets it when I'm gone. Okay, that was one method of estate planning. I still have clients come and say, don't worry about my collectibles, I got stickers on them. It's like, okay. What happens when the stickers fall off? What happens if somebody removes the sticker because they want that item? Right? That happens, believe me. Or another good one is always, well, I got everybody covered. See, I got a CD at the bank, and I got one for each of you, and it's got money in it, and so it's payable upon death. So when I pass, it's going to go to that person. Okay, that's nice, thank you. But what happens if the named beneficiary doesn't survive? Now where do those monies go? Now those monies may come into someone's estate and may now be subject to probate and may not end up going to the person you want them to go to. You know, the other good one was the family joint bank account. You know, we've got everybody on the savings account as joint tenants, and joint tenancy in Illinois law means if any one of those individuals survives, they get, by operation of law, the lock, stock, and barrel what's in that account. It's theirs. It doesn't go through probate, it automatically goes. So the old family plan was, okay, last one surviving gets it, and or, you know, if there's 3 of you left, you all divide it. You know, that was a means. Or sometimes it was, I'm going to put the oldest on that account, and so when I'm gone, you as the oldest have to divide it up amongst your brothers and sisters. That works real well sometimes. You know, the oldest goes, really, it's mine? I could just keep it? Bye. You know, they take it and they run. And sometimes it works, you know, in the best of circumstances. That person is diligent and they divide it, but they don't have to. So those kinds of estate planning are not desirable. We deal with more and different things these days besides having greater wealth than our parents. We're now dealing with extended families, which were never the case, and second and third marriages. And even if it's not you, it may be your children. So you may have grandchildren from different parents. And so how do you provide and protect those kids and make sure that they get a fair share of your estate or that they're taken care of at some point? So again, estate planning requires that we create legal documents, and the most important point that you have to keep in mind is that you have to have legal capacity in order to create those documents. Once you lose legal capacity, you can't do a thing. So, you know, why you need to plan. Number one, you avoid fights and disputes so that there isn't a knockdown, drag out when someone goes to decide who gets what items of property. Believe me, when greed is involved, characters change and problems occur. The best thing you could do for yourself and your kids is to have a plan, and you will eliminate any fighting. They may not like your plan, doesn't matter. It's your plan. You decide what happens with your assets. Again, you have a desire to protect and provide for your loved ones at your death. 3, again, you work hard during your lifetime to amass your stuff. And yeah, it's only stuff and it's not that important, but in the overall scheme of things, ideally you want to pass a biggest group of that stuff to your kids. That's one reason. The other, in your estate plan, you want that available for yourself. You know, you may have collectibles and accounts and things, but what if you need extended medical care or treatment? Where is that going to get paid from? And if you've got some lifetime protections in place, those assets could be available to be used for that care and treatment that you need or your spouse needs, even if it means using up all those assets and nothing goes to your kids. Number 4, if you plan, you will save money on taxes, attorney's fees, and court costs. Believe me, you know, I've been in court a long time, a lot of time. Stay out of court. Court makes attorneys rich. We like court. You shouldn't like court. We have great judges in DuPage County, but believe me, better for you to make your decisions about your estate than some third party to tell you or your family what's going to occur. Number 5, protect yourself during your lifetime if you become incapacitated. Extremely important, as we're going to talk about now, and we're going to talk about the first lifetime protection that you can put into place, and that is a power of attorney for health care. I am a strong advocate of creating a power of attorney for health care. It's a document that you create while you have legal capacity and will protect you in the event of your incapacitation. It covers health care treatment only. It has nothing to do with your assets whatsoever. It's a written document which you must create. So again, legal capacity necessary. You will specify an agent in that document to make health care decisions for you only if you're unable to do so yourself. So as long as you can speak or write or gesture, you control the medical care or treatment you get or you don't get. But if you can't communicate to your treating physician or your nurses, your designated agent under a power of attorney for health care will be fully empowered to make those decisions for you. This is a backup plan protection that each and every one of us should have. It's a flexible means to determine your treatment. So again, it's a grant of agency to a trusted agent whom you've selected, who will be able to field the data and information from the doctors and to make an educated guess about, okay, we should have this treatment, we should not have this treatment. Surgery's okay, no surgery. No chemotherapy, chemotherapy. Again, if you're alive and able to communicate, you make those decisions. But if not, your agent can step in your shoes and make that informed decision. A power of attorney for health care will take effect. It's a legal document when you create it, but the grant of agency to that agent does not arise until you become incapacitated. And you decide and define what incapacitation is. So in the terms of your document, you will state, my incapacitation means, and describe it. Generally, in most of my documents, I say that it's done either by a court determination that I'm incapacitated, or, the better one, my treating physician, who I've seen within the last 3 years, determines in writing that I'm incapable of managing my own healthcare decisions. Okay, that's important. In my opinion, that's important. So that you don't have a situation where one of your kids takes you to some new doctor you've never seen before and says, here's my mom. Isn't mom nuts? Mom can't do anything for herself. She's incapacitated, isn't she? Can you sign this for me? And maybe the doctor does or doesn't, but the point is, doctor has no clue of your medical history, what you've been like before, and so there's no standard to compare that by. So a protection for yourself when you do this is to define what incapacitation is. New law took effect this last January for the power of attorney for healthcare. This is a statutory creation. One of the good things our legislators have done. A statutory creation which allows this to be created. In 2015, as I just said, it's now become easier to create these documents than ever before. They eliminated some of the prior requirements. It does need to be in writing, but now you only need one witness. There are qualifications on who can witness your document, and they also eliminate any need to have a notary notarize any signatures. So there's really no reason not to have a power of attorney for health care. In this writing, as I indicated, you will name an initial agent to act, but you can also name successor agents to act. Those successor agents only become empowered if the first name agent is unavailable or unwilling to act. So it's a backup plan even for your agents. And again, you select who it is. You select someone who you trust to make the same decision for you that you would otherwise have made. That's important. That that agent needs to be over age of 18. And there are restrictions on, as I said, witnessing. And you need to give prior thought when you create these. And the prior thought that's now encouraged in the new forms is that you sit down and have discussions with your agent, whether it's your child or your spouse, in really, again, difficult discussions to talk about, hey, if this happens to me, this is what I want to do. Please put me on life support, don't put me on life support. Give me treatment, don't give me treatment. So when the time comes, they know what to do. Powers of attorney for health care lapse at death, with a few exceptions. Powers that extend beyond death is your agent has the ability to access your medical records. Federal law restricts access to those records. This document allows further access. Your agent has the ability to dispose of remains, so you need to discuss with your agent burial or cremation, and you can provide details to them so they know. Your agent also has the ability, if you allow them, to donate organs, and you can restrict the donation of organs as well. Believe me, doctors and hospitals prefer that you have what they call a healthcare directive, also called power of attorney for healthcare. When you walk in the door, what's the first two questions they always ask you? Do you have insurance? Do you have a healthcare directive? They want a direction as to who they look to for your care if you can't. They'd rather not be charged with their other responsibilities under the law, and that is to do everything possible to prolong your life, which also includes life support. So having a healthcare power of attorney puts that decision, if you can't make it, in the hands of your agent, and they'll know whether or not you want to be on life support or not. If you don't have a power of attorney for healthcare, there is a state law that controls who has the ability to make healthcare decisions for you. Some instances that's good, some instances not so good. So again, doing the power of attorney for healthcare, you choose who will make that decision. Power of attorney for healthcare is not a living will. Living will is just a static statement about what you want to do if you're terminally ill. To me, a power of attorney for healthcare makes more sense, it's more flexible, meets your needs when they may arise. And again, it's also not the same as a DNR, which is a do not resuscitate order, which is something that you would give to your doctor or physician. So 5 reasons why you should have a power of attorney for healthcare. You appoint your agent to make critical healthcare decisions when you are unable to do so. Again, you retain that ability so long as you're competent. 2, provide for the donation of organs after death. As I said, you may limit that. You may say, no, we don't know what condition your organs are going to be. That's not the question. If you want to give the possibility to your agent and maybe save another life, you can do that under this document. If you want to restrict the use of those organs, you can. You could say, I donate my organs only if they're going to be transplanted, as opposed to for medical research. Some people may not want to do that. You may say, only my liver, kidneys, heart, or only my corneas. That's your choice. Again, it's important to allow access to your medical records because only you, under federal law, have access to your medical records. Number 4, provide for disposition of your remains at death, whether that's burial or cremation. And number 5, most important as well, in the event it becomes necessary to go into court and get a guardian appointed for you, better for you to have a written preference designated somewhere of who that guardian would be. That's a process in court that if you do some of these lifetime protections, you'll never have to do. But if you do get there, you have a written preference as to who you would want to have serve as your agent and your guardian, the court generally will honor that in the absence of any major problems or issues. So that's always important to have designated as well. Further lifetime protection. Power of attorney for property. So again, another power of attorney form, but different from the healthcare one. This relates to your finances only. And if you have both of these documents in place, at least for lifetime protection, you've got a good start on a really good estate plan. Again, it's a document that you create. It's got to be in writing. Again, you have to have legal capacity. And you empower an agent to make financial and other decisions on your behalf, again, only upon your incapacitation. That's one way you can establish it. Again, it's a writing. It's got to be witnessed by 2 people, and it's got to be notarized. It could be a broad power of attorney for property, or it could be very limited in its scope. You can put restrictions on powers in that power of attorney for property as well. Typical examples of powers of attorney, probably some that you've experienced. You're buying a house, you got a closing. Husband can't be at the closing, he's working, only wife's going to be there, you got to sign your mortgage docs and everything. How do you do that? You create a power of attorney for a very specific act to complete that closing. That grant of authority to your wife is limited in scope, only to do the closing, not to deplete the bank accounts, and only to do what's necessary at that closing. When the closing's done, power of attorney ends, no grant of authority, act completed, all done. So you may have experienced that one. Or it could be for a period of time. Maybe you're traveling out of the country. Maybe you're in a canoe on the Amazon River. And you're completely out of touch. Even in this electronic age, you have no access to email or anything. You've got bills and things to pay while you're gone. How do you do that? Well, you create a power of attorney for a period of time and name an agent to act on your behalf during that time period. And that appointment of agency ends when you return and when that time period expires. So again, a very specific type of power of attorney. But the type that I advocate more is what we call a durable power of attorney. And that is, again, something that although you presently create, it arises only in the event of your incapacitation. So again, same way that you define incapacitation for the power of attorney for health care, you can do likewise for the power of attorney for property. So it's a standby document. It's sitting there ready to go, that if you're determined to be incompetent as you have defined it, you've now got an agent who could step forward and manage your affairs and make decisions for you so long as you are alive. Because all powers of attorney end and lapse when the grantor of the power of attorney dies. The exception is the power of attorney for health care in those few particulars. So a power of attorney is good, but again, lifetime protection only, does nothing with transferring assets at death. That's its only function. It would allow your spouse or your children access to your bank accounts and other information so they can take care of you, pay your bills, get you the medical care or treatment that you need. At all times, that agent that you appoint in that document acts in a fiduciary capacity. That means no self-dealing. That means acting in your best interest at all times. And believe me, it is enforceable. There are criminal laws in place that will give you subject to prosecution if you don't follow what's in the best interests of your principal. And you are personally liable if you don't as well. So there are protections in place to make sure that that agent acts accordingly. So 5 reasons why you need a power of attorney for property. You will appoint an agent to make financial and other decisions if you're temporarily or permanently incapacitated. And again, for both the power of attorney for health care and this power of attorney, your incapacitation may be a very short period of time. You may go in for a surgery, and maybe you're in a coma for a while, and then it kicks in, and your named agent can do the health care decisions and the financial decisions for you. And then you recover. Then you're back in charge, doing everything for yourself that you did before. So it can be on and off depending on your situation. That's the beauty of it. Number 2, you avoid the immediate need to get a legal guardianship. Again, that's going into court, petitioning the court. Any interested person can petition the court to become your legal guardian if you're incapacitated. They have to establish your physical incapacitation. But again, court costs, attorney's fees, time, all saved if you have a power of attorney for property. 3, allows your agent to manage your assets and pay your debts and expenses from your assets. So your kids don't have to dip into their accounts to pay for your medical bills or treatment or your mortgage or your utilities. They have access to your funds to pay those bills and expenses you're incurring. Number 4, you will name successor agents, just like the power of attorney for health care. So if your designated first agent isn't able to act, your next agent steps forward and acts. And 5, the importance is you will be the one choosing that trusted individual to handle your finances and make those decisions for you, as opposed to someone else doing it. So let's segue into what happens after death. We just talked about lifetime protections. Now let's talk about protections after death. Everyone at a minimum should have a last will and testament. Is it the best thing to have? No. Is it a minimum thing to have? Yes. Your will is a written document. It is merely your written blueprint of what happens with your assets in your name only at the time of your death. You're going to hear me repeat that phrase ad nauseum for the next few minutes. Assets in your name only at the time of your death. That's all, the only thing, the only category of assets that your will controls. Again, a will gives you no lifetime protection. It's your last will and testament. Only becomes such when you die. You can have 20,000 versions during your lifetime. Literally, I have some clients that come in to see me almost once every 6 months to redo their will because niece this month didn't, or over the last 6 months didn't visit enough, so now she's out and the nephew's in until the next 6 months, and then it reversed, and so we're going to change it again and bring one in and take one out. As long as you're alive and capable, you can make any changes you want in the will, and until you die, it's not your last will and testament. Again, it only has effect at your death. It only controls assets in your name only. It has no effect on assets that you may hold in joint tenancy with someone. It has no effect on retirement benefits. It has no effect on life insurance proceeds unless you've named your estate as the beneficiary. Having a will does not avoid probate. We're going to talk about misconceptions in a little bit. Everyone thinks having a will, everything's wonderful, fine. It's not. Okay? What determines whether my estate goes through probate? If I have assets in my name only at the time of my death that exceed $100,000 in value. If you own a house and all you have is a will, your estate's going through probate. Probate is an avoidable procedure in court. Again, it's court, judge involved, attorneys involved, court costs, all avoidable if you do some other things, as we'll talk about. Okay? Will has to be created with the proper formalities in this state. It has to be in writing. It has to be properly witnessed to be an enforceable, valid will. There are roles you create under the terms of a will. You are the testator. You create it. You have legatees. Those are the people that receive the benefits under the terms of your will. You can make specific bequests under your will, which are specific grants of specific items of property to people, or grants of money if you support a charitable organization. I don't know, maybe like the Elmhurst Heritage Foundation, and you want at death to make a specific bequest to them of amount of money to use for a specific purpose. If you put that in your document, it's legally enforceable. They will get the monies for those purposes. So if you support a charity or an institution, very effective way to do that. Another reason to do a specific bequest, maybe you've got a family heirloom that you want to make sure gets passed down to your daughter or granddaughter, stays in the family. If you name it, describe it, and it's in existence at the time of your death, it will go to that person. Those are legally enforceable bequests. And they're done before the dissipation or expenditure of other estate assets. Otherwise, we look at general bequests, which is everything else that I have, both my real and personal property at the time of my death, goes to my spouse. And if my spouse doesn't survive, then my children in equal shares. Or if my children don't survive, then to my grandchildren. Again, as we draft and plan, we cover reasonably foreseeable events. A will only gets filed at the time of death, and at that point it becomes a public document. Everyone's heard recently, will contests. What's been in the news recently? I'm a Cubs fan, as I said. What's been in the news? Ernie Banks' will, right? Ernie Banks' will contest in court. That he created a will shortly before death. He has a caretaker agent. all of a sudden she's the primary legatee of the will. His wife and kids aren't getting anything under the will. So right away everyone's worried that some undue influence, something occurred to force him to create the will, which he wouldn't otherwise do. He went to court. Again, will contests, another fiction of TV and movies. Very difficult to prove. Very specific grounds you have to establish in order to invalidate a will. And as we just recently saw, although a lot of things look kind of questionable, the judge upheld the will as being fine. Just because you don't like the share you're getting under the terms of a will doesn't give you the grounds and reason to contest it. If you're written out of a will, oh well, too sad. You have no right to be named. That creates no ability on your part to contest it. There are very specific grounds, as I said, in how to contest a document, such as the person didn't have capacity, it wasn't properly prepared, or there was undue influence exerted upon the individual. They happen, believe me, those things occur, but they are difficult to prove, and the burden is on the person that's trying to contest the document. Another thing that you should know, clear up a misconception, as opposed to what you see in TV and movies, there is no reading of the will that's required. I get that all the time too. I get a phone call, it's like, my uncle died and he had a will and they didn't call me and didn't do the reading, so what can I do? It's like, nothing. There's nothing that requires any formal reading. That's just for TV dramatic purposes. Again, if you're not named in it, you're not going to get anything. If there were no assets in the estate, it doesn't even need to get filed necessarily. If it's filed, it's a public record. You can go get it. You can read it yourself. But there is no formal reading. So 5 reasons why you should at least have a will. Provides your written direction of what happens with your assets at the time of death. Again, assets in your name only at that point. You appoint a trusted individual to enforce the terms of that will, and it is enforceable. 3, provide a plan of succession for your executors or asset recipients. Again, what happens if my wife doesn't survive me, or if I leave children or don't leave children, or if only some of them survive? 4, in the event probate becomes necessary, you can waive the requirement to post a bond or surety, saving probate expenses at that stage if your estate does need to go through probate. And 5, you can ensure the family heirlooms or collectibles won't be sold and they'll be distributed to those that you want to receive. So the importance of doing a will. Let's talk about another lifetime protection, but also a protection at the time of death, and that is a trust. You hear the term trust used all the time. A trust is, again, a legal document which you have to have legal capacity to create, and it creates a separate legal entity, and it's a means to own and hold property. The technicality is you're separating what we call legal title from equitable title, but the bottom line is a presently acting trust agreement which can control those trust assets that are transferred into that trust according to the terms of the trust agreement that you create, and you decide what those terms and conditions are. You provide for the management of those assets and how the income is used and how the principal is used, not only for yourself during your lifetime, but also after your death. Important to know that having property and assets in the trust makes those assets exempt from probate, regardless of the amount. So we talked about probate threshold, $100,000 of assets in your name only at the time of your death. You can have millions of dollars in the trust. They will not go through probate in the state of Illinois. You save court costs, attorney's fees, and scrutiny by the court if you have a trust. A trust agreement is a confidential document. It is not a public document. It is never filed or recorded anywhere, unlike your will, where, as I said, within 30 days of date of death, it's supposed to be filed, which means anyone could go and look it up and see what's in it. A trust becomes effective upon its creation and can, if you so choose, provide lifetime protections in that document. There are roles you create in the terms of that document. There's a grantor, which is the creator. You've got a trustee who manages the assets according to the terms of the trust agreement. You have beneficiaries who receive the benefits of the management of those assets, all as described in that trust agreement. Again, a trust only controls assets that are transferred in, and you must physically transfer those assets into a trust. If you own a house, the way you do that is you execute a deed, you record the deed, and that transfers ownership of that real property into the name of the trust. While the trust is in effect, you will have if you reserve the right to yourself, to use the income and principal. And the most common trust, the most simple type of trust that would provide you lifetime protection is known by a lot of different terms, which is what confuses people in this area. It could be called a living trust. It could be called a grantor trust. It could be called a revocable trust. It could be called a self-declaration of trust. They're all the same things. It means it's a trust that I've created for myself, for my benefit, to manage my assets for me. It allows me to manage those assets like I'm doing now without a trust. Doesn't change, unfortunately, doesn't change your taxable income situation with that type of trust. It's a flow-through trust, but I could still file my same individual tax return. I still use my Social Security number. I still get all the exemptions and deductions I'm otherwise entitled to. But what it does do, it does provide, if I include the provision, that if I become incapacitated, a successor trustee will come in and manage all those trust assets for my benefit and use the income and or the principal as I designate for my care and needs. So that's a lifetime protection. And then at my death, there's an immediate and automatic distribution of those assets without court involvement, without probate, without court costs, without attorney's fees. Those are important. Trusts are not for everyone, and we'll talk a little bit about restrictions and things. This is a simple type of trust. It may not be the best thing for all of you, but I would venture to say that for most of us, a simple living trust works best and would apply for more people than not. There's also another type of simple trust that I'll cover briefly. In the state of Illinois, it's called a land trust. 8 states across the country allow by statute the creation of a land trust. Works like any other trust with the exception of that a land trust can only take title to real property, which means your house and the land in which it sits on. You can have multiple pieces of real property in a land trust, but it can only be real property. So you can't put bank accounts or investments or anything else in a land trust, only real property. But as part of a simple estate plan, maybe having a land trust taking the value of that asset out of your potential probatable estate means that you can have a simple will and you won't have probate and everything is fine. So land trust sometimes is a very viable thing to consider. So why you should have a trust, and again, in general terms, and all this is always couched with, for your individual needs, you need to sit down with an experienced estate planning attorney to assess your particular situation. What's your income? What's your wealth? What are your goals? And they will give you paths that are available to you that you can take. So it's not one size fits all by any stretch. But it does provide a lifetime protection, allows the successor trustee to manage your assets upon your incapacity, and then at death to pass automatically. You avoid probate. It provides your detailed plan of distribution of assets, so you can provide your assets at the time of your death go to your spouse. If she doesn't survive, it goes to your kids. Well, maybe one of my kids is like 16, and so he can't hold title to property if I were to die tomorrow. So I can set up a children's trust in the terms of that original trust to delay his receipt of his full share, but have it available for his educational expenses or his medical care. And then, maybe at age 25, he gets his share. But prior to 25, I have a trustee that says, no, if I give you the full amount of money, here comes the new Porsche down the street. Okay, but I want you to go to school, and if I were alive, I would have paid for your tuition. And since I'm gone, I'm going to make sure those assets are held for you for good purposes, and then later you'll get them. It does provide immediate distribution to your named beneficiaries, again, but that possession can be delayed, as I just said. And 5, again, it saves money on court costs and attorney's fees because you won't be in court. So that kind of gives you an overview of some of those concepts. Let's talk about misconceptions and problems that we encounter along the way. Starting with misconceptions about trusts. Everyone believes that trusts aren't for everyone. As I said, that's not true. There are simple types of trusts that you can inexpensively create to meet your needs. Now, if you're Donald Trump and you have gazillions, although if you really know he doesn't have gazillions, a lot of it is on paper. But if you have a lot of wealth, then there is sophisticated trust planning that you could do to not only maybe save income taxes, but certainly to reduce, avoid, or eliminate federal estate or Illinois estate taxes later. So if you have more money, it's even more important to plan and to make sure that that effective plan takes into consideration those tax consequences. They're not too expensive to create. Simple trusts are not that expensive. Most estate planning attorneys work on a set fee basis. It's not an hourly rate basis. So believe me, you're not spending hundreds of thousands of dollars. You can create a very effective estate plan probably for under a couple $1,000s. Again, depends upon what you're doing and how complicated that the documents are. But don't assume, oh, I just can't afford it. You may be able to afford it. And a lot of times it comes down to an analysis of, would I rather spend a little bit now and have lifetime protection and make sure that my assets will pass outside of court and probate to my wife and family, or do I want them to bear the brunt of all those expenses, which are going to be significant later, and deplete anything that I leave to them so that there's nothing left? 3, I don't have enough assets. As I said, you don't have to have great wealth to create a trust whatsoever. We're not talking about setting up a trust at an institution to manage. If you were looking at having a corporate trustee, yeah, they have thresholds, and they will not take certain trusts under certain amounts. They're not too complicated, as I said, and trustee fees will not consume your assets, particularly if you look at setting up a living trust and you're naming yourself as your own trustee. You don't need to pay yourself to manage your own assets for your own benefit. 5 misconceptions about wills. If I have a will, my estate will not go through probate. That's the number one thing we hear all the time. Not the case. Having a will does not avoid probate, as we said. It's the value of assets in your name only at the time of your death. Number 2, if I have a will, I'm fully protected. No, your will gives you no lifetime protection. So if you have a concern about your medical care or treatment, a will not do anything for you. It only takes effect at the time of your death. 3, if I have a will, I've provided for the handling of all of my assets at death. No, your will only controls assets in your name only at the time of your death. It has no control over assets in joint tenancy. It has no control over assets in trust, no control over IRAs or 401ks or life insurance proceeds. Number 4, I don't need a will until I get older. Again, as we've talked about, I don't care how old you are, you ought to have one. When my kids turned 18, and granted I'm an attorney and I do this for a living, each and every one of my kids at least had a will. It's important to make sure that people are protected, especially those of us as we're getting older. Do the planning, do the will or other documents while you have legal capacity before the crisis occurs. Here's a big one. I did a will online, so everything's covered, I'm fine. Know that many online documents that you will see are not comported with the laws of the state that you may be living in, particularly Illinois. It's a generic form that they have out there. And you are taking a risk, if you use that form and create it, that when the time comes, it may be invalid and unenforceable. For the little money that you're paying, and there isn't that much difference sometimes between what you see online and what an attorney will charge you, it's better to have a licensed attorney do it where you know that know what they're doing, and it will be enforceable when you need it. Again, a lot of online wills do not contain proper provisions for witnessing. They contain no instructions of what to do with them, and so they're not very good at all. Again, you're just buying a document when you go there. That's not what you want to do for estate planning. If you go to an attorney, you're not just paying us for the document. You're paying us for our expertise and our experience and a knowledge that we're licensed to know what we're doing, and that when we do something for you, it will be effective when the time comes. 5 common mistakes that are made in estate planning. Again, use of internet sites, the prepackaged forms, or the one that we always love to. A family member will go to their attorney and have documents done, show them to a sibling, and go, hey, that's nice, I like your documents. Those are really well done. Can I borrow them? And they sit at the word processor and they try to redo the documents for themselves, without knowing that, that document was specifically prepared for that person, and your situation may be different from your sibling, and so you can't just copy the document and that it's going to work for you. A belief, again, that family discussions and understandings and the label thing will work. They're not legally enforceable. They will not. An understanding that the importance of titling of assets. Again, if you have a life insurance policy and you have a designated beneficiary, those proceeds go immediately and directly to the named beneficiary. But if that beneficiary doesn't survive you, where do those proceeds go? It goes into somebody's estate. Maybe it's your estate, maybe it's your kid's estate, and that estate may now be probated because the value of those assets, or that asset, exceeds $100,000 in and of itself. So we always say, make sure you have a check of beneficiaries on all of your documents. Make sure you have a primary beneficiary. Make sure you have a contingent beneficiary. Understand, again, the importance of planning now before a crisis occurs. Again, crisis planning, not a good thing. Unfortunately, we deal with that a lot. Better to plan when you're rational and calm and can think through what you want to do. And again, failing to have an attorney perform a periodic review. And just because you did a will 20 years ago doesn't mean it's still good. It may be valid and an enforceable will, but it may not now meet your life circumstances. And as best we do a job of incorporating reasonably foreseeable circumstances in the drafting, we can't foresee that now you're divorced after you created the document, or other important life changes have occurred. It's up to you to pull those documents out on a regular basis and to look at them and make sure that they're going to do for you what you originally intended them to do. So in conclusion, a couple things, again, to stress. Plan. Don't delay. Avoid the crisis planning. Review your docs with your estate planning attorney. And create an estate plan that will work for you and cover you in the event of your incapacitation and then upon death. If those words of wisdom get through to you today and prod you to do some action, then I've done my job. So thank you for your time and attention. It's been my pleasure. And after the broadcast ends, as I said, I'll stick around and answer any questions. Thank you.
Let's give Michael another round of applause. He's really given us a lot to look forward to as far as planning goes. On our education committee for the commission, that's one of the main thrusts that we have, is that we want to make sure that people are armed with the right information at the right time to make good decisions. And we hope that this presentation has helped you do that. I would like to make a short announcement. On April 22nd, we are going to be having a housing and transportation fair at Wilder Mansion from 9 until 12 o'clock. And we're having that because every other year we have what we call a collaboration committee that meets with all of the non-for-profits in town and all of the churches. And one of the things that they requested, because they get a lot of questions about housing and they get a lot of questions about transportation. And so I encourage you to come. The only thing I would share with you is we've been told that please do not park on the Elmhurst College campus. So there's plenty of parking around and there's handicap parking, and we hope to see you then. Before closing, I always like to give a little words of wisdom. Being happy doesn't mean everything is perfect. It just means you've decided to look beyond the imperfections. Thank you for attending Community Conversations, and make it a good day. Thank you.
Hello, my name is Battalion Chief Don Novak with the Elmhurst Fire Department. Did you know that over 85% of the child passenger safety seats are installed incorrectly? Here at the Elmhurst Fire Department, we offer a free child passenger safety seat inspection. All you need to do is call City Hall at area code 630-530-3090 for an appointment. Area code 630-530-3090. Because we care about your children.